Hey, hello, student. Hello, my colleague. Hello, hello,
Hello,
hello.
sir.
Yes, sir.
Please, I'm sorry.
Yes, sir.
Please, I'm sorry. I'm
Can
sorry.
hear you.
I'm so sorry. I apologize. So I was trying to go back a little on where how we concluded with Tuesday, that this concept of land use act appears to have rendered nugatory, on the face of the the uh, the, the doctrine of estate by virtue of section 1, by virtue of section 5 and 6, by virtue of section 35, 34 and 36. Remember that section 1 vests all the ownership of the land in the state in the government, and therefore section 5 and 6 is more or less talking about express grant by the government in respect of the land in the urban region, while the section 6 is talking about express grant in respect of the local government for land in the non-urban region. This express grant cannot give you more than right of occupancy, and the right of occupancy is measured in terms of maximum of 99 years. Whereas there is express grant provided for in section 5 and 6. There is also what we call the deed grant in section 34 and 36, saying that if you have owned a land since beginning or before the advent of land use act, you are deemed to have right of occupancy over that premises. And also, it is in the non-urban area. Section 36 makes it the occupier who is deemed to have right of occupancy in respect of the city. And some argument has been, have been profiled to say that even though section 5 and 6 appears to have swept away doctrine, doctrine of freehold estate, but section 35 and 36, because you do not need to present yourself for certificate of occupancy, because you are deemed to hold it, and then nobody is measuring the number of years for which you are going to hold it. It is deemed that that right conferred on you by virtue of section 34 and section 36 will more or less, amount to, to freehold. Now, coming back to where we are supposed to have started today, it should be noted, however, land use did not sweep away the existing interest on land, but it merely converted. Hello?
Sorry, sir. Sorry, sir. Your network is the network is breaking, so we can hardly hear your words clearly.
Can you hear me now? Can you hear me like this? Hello? Hello?
Sir, maybe you should log you should go out and come back to be better.
Okay, I should log out and come back. Okay. No problem. Hello? Hello?
Yeah, we can hear you now, sir.
Okay, thank you very much. Sorry, thank you for being patient with me. Now, we said we should note that land users did not totally sweep away any existing interest on land. It didn't totally sweep away, or let's say it did not even sweep away the existing interest on land. But what it has done is to convert all the unlimited rights on land to rights of occupancy. It has converted all the unlimited rights on land to rights of occupancy. Now, what do I mean? You remember that under the doctrine of estate that existed before the Land Use Act, you can have freehold, which is capable of being inherited by your ascendants, by your descendants, by your relatives. Okay. Now, that freehold is capable, if it is fee simple, is capable of being held for a period that cannot be determined, for such a long period that you cannot even calculate, so long as those conditions of grants are actually met, and that those conditions attaching to the vesting of the interest is in existence. As long as there's any heir who can inherit, either from your descendants or from your ascendants or from any of your relatives. Okay. Now, that is what freehold, estate is all about under the doctrine of estate. But what we're now saying is that with the commencement of Land Use Act, that ability to hold a land under freehold, particularly if it is fee simple, for a period of time that is not determinable, has been modified by Land Use Act. By doing what? By converting your unlimited rights on the land to rights of occupancy. That conversion of your right is done expressly by virtue of Section 5 of the Land Use Act, and for land in urban region, and expressly by virtue of Section 6 for land in non-urban region. And it has also gone ahead to say that for you that you have held this land before this time, the land user is coming to operation. By virtue of Section 34, for you that you are occupying in the urban region, then what that means is that, well, we deem that you have a right of occupancy. We deem it that you have a right of occupancy. In the non-urban region, by virtue of Section 36, we deem it also that you have a right of occupancy. And that's what we are saying about this paragraph, that what land users has done is not to sweep away our existing interest, but to merely convert all unlimited rights on the land to rights of occupancy. So your right that existed under fee simple, that makes it impossible for anybody to determine the number of years for years for which you are going to hold it, so long as you have heir apparent to the throne or to the estate who can inherit, no longer exists. It has been cut short and has been modified to become a right of occupancy. And that's the point we are saying here. However, a right of occupancy, remember, is the right to use, occupy, to use and occupy the land to the exclusion of all other persons except the governor. Of course, in relation to deemed right that I've mentioned, you can see the case of Savannah Bank and Agilo. See Savannah Bank and Agilo to support the position of law regarding Section 34 and 35 relating to deemed right of occupancy. Then showing that our doctrine of estate, whereby we have fee simple, making it possible for us to have a freehold that we cannot determine the number of years for which we can hold it, has been limited to right of occupancy. We can see the case of Zungwe and Gbiche. See Zungwe and Gbiche, see Salami and Oke, see also Ogunleye and Oni, see Ogunola and then Eyekole. Taking it again, I said that for that submission, saying that, Land Use Act has swept away has not swept away any existing right on land, but has merely converted all unlimited rights on land to right of occupancy. You can see Zungwe is spelled D-Z-U-N-G-W-E, Gbiche is spelled G-B-I-S-H-E, and also see Salami and Oke, see also Ogunleye and Oni, see also Ogunola. Ogunola is spelled O-G-U-N-O-L-A. Eyekole is spelled E-I-Y-E-K-O-L-E. So now, that having been said, I now said that when I was talking about the deemed right as preserved by Section 34 and Section 36 of Land Use Act, please see the case of Savannah Bank and Agilo. I went further to mention that a right of occupancy is the right to use and occupy the land to the exclusion of all other persons except the governor. You can see the provision of Section 15. See Section 15 of the Land Use Act. Section 15 of the Land Use Act. However, note also that a holder of such rights therefore has the right to secede. He has the right to secede, and the quantum of interest enjoyed by him, that is that right of occupancy on the land, is what is referred to in English law as estate. So I'm saying that a holder of such right of occupancy has the right to secede, and the quantum of interest enjoyed, which is a right of occupancy on land, is what is referred to in English, in English law as estate. The holder of a right, therefore, has the right to secede, and then the quantum of interest that he enjoys is more or less right of occupancy on that land, is what is referred to as estate under the English law. However, note also that since estate represent the measure of a person's right to secede, is your measure of your right to secede that is referred to as estate. And remember, the distinction we are making here is that your measure of your right to secede, in some cases, may be infinite. That ability to make your estate to be infinite that exists in the English doctrine of estate no longer exists in Nigeria by virtue of Land Use Act of 1978. So what we are trying to say is that the doctrine of estate has not been swept away, only that it has limited the infinite nature of some of your freehold estates that may exist in the land as we have it in England. I'm not sure whether I'm making any point. Hello?
Yes, sir.
Hello?
Sir,
Yes,
can I
sir.
come again?
Okay. So, I said that, you see, under doctrine of estate, that you could have some estates that could make you have a measure of right to secede that is infinite. A measure of right to secede that is infinite. That measure of right to secede that is infinite is freehold. An example of it could be fee simple. But that doctrine that you can have estate has not been swept away in Nigeria. Only that it has limited some of the features of that. It has limited some of the features of that English doctrine of estate that we have inherited. So what we call right of occupancy, it has become, you can only have a definite measure of right to secede under this definite measure of right to secede under the Land Use Act. Whereas under the English doctrine of estate, there are cases where you can have infinite right to cessing. I'm not sure whether I'm making any point. Hello? Hello?
Yes.
Hello?
Yes,
Hello?
sir.
Does it make
Yes, I
sense
said
to
we
us?
can have it.
We can hear you,
Okay.
sir.
So we can.
Hello? Hello?
We can
We
hear you.
can hear you, sir. We can hear you.
Okay, you can hear me. So I'm trying to figure out whether what I'm saying, whether you understand, whether you have understood and saying, before I move on to the next point. That's my challenge. I
We
wanted to find
understand.
out.
Move on, sir.
Okay, you understand. Okay, fine, thank you. God bless you. Now let me move on to the next point. Thank you. I want to leave that corner. Maybe it's affecting my network.
Sorry, sir.
Okay. Hello?
Sir, are
Hello?
you saying that there are some persons that have estate that can have a finite can have an infinite freehold?
Under the English law or under the Nigerian law?
Yes, sir. Nigeria.
Under Nigerian law. Yes, that's what I'm saying. We are coming there. That if by arguments, there's nowhere, it is not expressly written anywhere that your estate can be infinite again. Your estate has been expressly written to be finite, that is not more than 99 years. But we are saying that if we are coming to that argument, if you follow the argument of learned Professor Smith, STN, he's trying to tell us that the dim rights granted in section 34 and 36 could give you infinite rights to cessing, even though they are saying that, even though land use act is saying that your rights is now determinable, your rights is now finite. But he's saying that the way section 35 and section 34 and 36 is couched, if interpreted in a technical way, you'll find that it is possible for you to have an estate that is infinite. We'll get there. But I want to get to know that what Land Use Act has done. I'm saying this loud and clear so that we can understand that what Land Use Act has done is not to sweep away the doctrine of estate totally. Estate is also given by virtue of right of occupancy. But what right of occupancy has done is to limit our unlimited right in land to a definite one, which is usually not more than 99 years in respect of any right of occupancy that is given to you. Did I make myself clear?
Yes, sir.
Okay. All right. Let's move on. So we said. So now, what that means is that, since estates represent a measure of the person's right to cessing, a holder of right of occupancy under the Land Use Act is also said to be an estate holder. That person is also said to be what? An estate holder, because remember we said that your estate is a measure of your right to cessing. So a measure of your right to cessing under the measure of your right to cessing under the Land Use Act is maximum of 99 years. So we can still say that under the Land Use Act, you are also, a holder of estate, because it has told you exactly what is the measure of cessing that you can have. Only that it is no longer possible for you to have a measure of cessing that is infinite, like you used to have under the English doctrine of estate. Remember that we said that your estate could be infinite if it is a fee simple, and all those conditions of grant would continuously be present. So now listen to this argument that we're about to make relating to that query raised by our dear friend just now, that was I saying that it is possible for us to have an infinite right to cessing, in spite of the fact that land use act has said that you cannot have more than right of occupancy. Please listen to this argument very well. Now, although the question whether freehold exists under the Land Use Act has been answered to the negative by judicial authority. Are we together? It has been answered to the negative by judicial authority. Of course, you can see all of those cases that I've mentioned before, Zingwe and Biche, Salami and Oke, Savannah Bank and Agilo too had actually mentioned the same thing. But what we are saying here is that the distinction, I get to my point, that is the estate enjoyed by grantee under Section 5 and Section 6 of the Act, and that exists under Section 34 and 36 remain a factual phenomenon in spite of this judicial legislation towards equating two distinct interests. So what we're trying to say is that though judicial authority have said that it is not possible for you to now have freehold estate in Nigeria by virtue of Land Use Act, but we are saying that the interest that is given to you by virtue of Section 5 and 6 are not the same thing as interest that you acquire by virtue of Section 34 and Section 36 of Land Use Act, notwithstanding this judicial pronouncement stated this judicial pronouncement in Zungwe, and then Biche, Salami and Oke, and the rest of them. So now,
Sir, sorry.
Yes, say it.
Please, can you
Say
come again, sir? What you just explained. Can you come again, sir?
Okay, what I'm saying is that although the question whether freehold estate exists under the Land Use Act has been answered to the negative, it has been answered in the negative by judicial authorities. But we're saying that there's a distinction between grantee, there's a distinction between the interest, there's a distinction between the interest enjoyed, there's a distinction between the interest enjoyed by the grantee under Section 5 and Section 6 of the Land Use Act, and the interest that exists under Section 34 and 36 of the Land Use Act, because the two of them have distinct interests. Are we together? Are we together? Are you together with me?
Yes,
Yes,
sir. Yes, sir.
sir.
Okay, so we're trying to establish how the interest enjoyed in Section 5 and 6 is different from the interest enjoyed in Section 34 and 36. Now, while it is a fact that grantees under Section 5 and 6 have estate less than freehold, they have estate less than freehold in the sense that the document that is vesting right of cessation, that is the certificate of occupancy, that is the vesting right of cessation, right of occupation in them, limits their interest to be enjoyed to 99 years. Section 5 and Section 6, are you getting my point? Is to the fact that while it's to the fact that grantees under Section 5 and 6 have estate less than freehold, in the sense that the document that is vesting the right of cessation, that is the right of cessation to them, by virtue of that certificate of occupancy, limits their interest to be enjoyed to only 99 years. Whereas deemed grantees under Section 34 and Section 36 enjoy, as a fact, an estate akin to freehold estate. They enjoy what? An estate akin to, that is likened, that can be likened, that is similar to freehold estate. Why? Why is it so? The reason why it is so is because his interest is not limited to any time of years under the Act. The man whose interest is a deemed grant under Section 34 and 36 does not have his own interest limited anywhere in that Act to any time of years under the Act. Does that make myself clear? Hello?
Yes, sir.
Yes, sir.
Okay, so what we're trying to say is
Yes,
that the
sir.
right, so the right, so we can say that the Land Use Act has actually limited estate to or limited our estate or our right to cessation to what can be likened to right of occupancy, which is measured in terms of 99 years by virtue of Section 5 and Section 6. But what we are saying is that in the same breath, in another breath, it has actually granted, it has actually granted right to occupancy, what's it called, it has granted the right of occupancy to whoever is the occupant of the land by virtue of, please give me 1 minute. Please give me 1 minute. 1 minute. Hello? 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 Hello?
Hi.
Yes, sir, we can hear you.
So
Oh, we can hear you.
so what I'm saying is that the right of occupancy that is granted in Section 5 and 6 is limited to 99 years. Whereas Section 35, 34, and 36 only says that I have a deemed grant, which does not specify the number of years that I can enjoy. So usually when you want to have a right of occupancy under Section 5 and 6, what they will normally put in your certificate, the maximum they have ever given anybody in terms of that certificate that is issued is 99 years. Although I have checked the length and breadth, of Land Use Act, there's nowhere it is mentioned that your right is limited to 99 years. But in effect and in practical terms, when they are going to give you certificate of occupancy, the maximum you can get is 99 years if that right is conferred on you by virtue of Section 5 and Section 6 of the Land Use Act. But what we are now saying is that the deemed grant has an estate that is similar to freehold estate, since its interest is not limited to a term of years under the Act. So the Act only said that you have a deemed grant of right of, but did not in anywhere, because it does not stated in anywhere that your right is limited to a social number of years. So we say that that right is more or less a freehold estate by virtue of that, technical distinction that we're able to make. So such a deemed grantee is also not obliged to so limit its interest by obtaining a certificate of occupancy, which creates a term of years. Because what this one is saying is that there is no provision of the Land Use Act that says that you must come forward to obtain a certificate of occupancy. So that's why I'm saying that such a grantee is also not obliged to so limit its interest by obtaining a certificate of occupancy, which creates a term of years. The law stops at saying that if you own it, if you occupy it, and you are deemed to be the occupier by virtue of Section 34 and 36 before the advent of Land Use Act, you will be deemed to be the to be the deemed grantee of the land. The deemed grantee is not required to come forward to come and obtain certificate of occupancy, and the right that is given to him is said to be such that is akin to that of the freehold estate. Now, the factual status of a deemed grantee as the holder of freeholder, as the holder of freehold interest is not inconsistent. Is not inconsistent with the position of the governor as the owner of all the land that is comprised in the state. I state that again. Even though we said that it has reduced right to right of occupancy by virtue of Section 5 and 6, Section 34 and 36, we said that the one in 5 and 6 is more or less a right of possession that is measured in limited terms by virtue of saying that you cannot have more than 99 years usually expressed in the certificate of occupancy that is given to you, even though no number of years is stated in the Land Use Act. I've not found anywhere it is so mentioned. And then we say that the right that is enjoyed by the person who has a deemed grant is more or less, an interest that is akin to that of freehold, because its interest is not limited to a term of years under the Act, such that a deemed grantee is also not obliged to come forward to say, I want to obtain a certificate of occupancy by which, his own term of years can be limited to 99 years. And then we say that the factual status of a deemed grantee as a holder of a freehold interest is not inconsistent in any way. It's not in any way inconsistent with the position of the governor as the owner of all land comprising the state. Now, it goes further to tell us that such ownership that is contemplated under section 34 and 36 must be viewed as nothing more than the kind that is vested in the crown in England in respect of all land in the territory. Theoretically, all land is vested in crown of England in respect of all land. All interest in land, all land in oh God. So theoretically, all land is vested in the crown in England as the owner of that land. The same also applies here, and we are saying that this deemed grant in section 34 and 35 is not inconsistent with that right of the governor. So we're not saying that if the theoretical ownership of crown in England is not a bar, if the theoretical ownership of theoretical ownership of the crown in England, theoretical ownership of land, theoretical ownership of land of the crown in England is not a bar. It's not a bar to the existence of freehold estate in England. There cannot be any objection to conceiving of the existing rights under section 34 and 35 as freehold estate. So the point I'm making here is that the rights that we have under section 35, 34 and 36 is more or less like that of freehold estate that we have in England, because the rights that we enjoy there is not limited to any time of year under the Act. You are also not under the obligation to come forward to come and obtain certificate of occupancy that will limit your right to settle to a term of year. And this status that we are talking about of a deemed grantee as a holder of freehold estate is not inconsistent with the position of the governor as the owner of all land comprised in the state, as provided for under section 1 of the Land Use Act. Because the ownership that you are talking about, the ownership must be viewed as nothing more than that kind of ownership that is vested in the crown in England. It's not more than that kind of ownership that is vested in the crown in England in respect of all land in the territory. And the logical conclusion to be made from here is that if the theoretical ownership of the crown in England is not a bar, is not a hindrance to the existence of freehold estate in England, therefore, there cannot be any objection to conceiving the existing rights under section 34 and section 36 as freehold estate. I'm not sure we are getting the point I'm making. Did you get it?
Okay, sir.
Hello?
Yes, sir.
You got it? Okay.
So, sir, yes,
All right.
yes. I'm saying that as long as you're a deemed grantee, you
Yes.
don't have to come out to ask for a statutory right of occupancy.
Thank you.
Uh,
Yes, go ahead. Yes.
And you said theoretically that if the crown is vested, I don't know, I did not get that, please.
No, if the crown. Now, so it follows by extension that if to say that you have a deemed grant under section 34 and 35, section 34 and 36 does not in any way conflict with the Provision of Land Use Act that says that your right is now limited to right of occupancy. Are you getting my point? And does not conflict with the right of the governor to be the owner of all the land in that state. Because it is not only in Nigeria that governor is made to be the owner of all the land. It is a theoretical thing. In England too, Crown is deemed to be the owner of all the land in the territory. Even though the Crown is made to be the owner of all the land in the territory, it still does not stop them from granting freehold estate that is for a measure of cessation that is indeterminable or that is for infinite period of time. So in the same vein, holding a deed grant under Section 34 and 36 does not conflict with Provision of Land Use Act, and that it does not mean that your estate cannot be a freehold, which will still continue to exist, for infinite length of time. I'm not sure whether anybody understood what I'm saying.
Yes, sir, I get it. So the governor cannot come and take your land, even if he still has the right to or has title to all the land in that particular country or in Nigeria.
Unless he has come to acquire it by virtue of this acquisition and revocation under Section 28 or for any reason. There are good reasons why government want to take your land. If they take your land based on anything that is contrary to what is stated and contrary to the procedure that is stated in the law, you certainly can object it. Are we together?
Yes, sir.
Okay. So now, what we're trying to say is that the system of right of occupancy postulated by sections 5, 6, 34, and 36 of the Act appears to be rendering obsolete the concept and all the terminologies, of English, doctrine of freehold estate. 1 minute, please. Hello?
Hello, sir.
Okay, so the system of right of occupancy postulated by Section 5 and 6, Section 34 and 36 of the Act appears to have rendered obsolete the concept of doctrines, the concept of estates, and those terminologies of English freehold, such as fee simple, fee tail, life estate, together with their respective techniques of creation. Are we together?
Yes, sir.
Yes, sir.
Okay, so
Sir.
the doctrine of estate as related to leasehold estates, however, still remain under the Land Use Act. And then to that extent, I would refer you to deemed grants. I will refer you to Section 5 and Section 6 to the extent that I'm establishing that doctrine of estate as it relates to leasehold estate, remains under the Act. So see Section 5 and Section 6. Whereas we are saying that it has kind of rendered obsolete the concept and all the terminologies referring to free real estate, such as fee simple, fee tail, and so on and so forth. This was more or less, still more or less land use act telling to us. So now, section 25 of the Land Use Act, in relation to this discussion, now says that it is basically 75 of Land Use Act is basically dealing with transfer of land not subject to customary law by providing that no deed or will shall operate, no deed or will shall operate to create any proprietary rights. No deed or will shall operate to create any proprietary rights over land except that of a plain transfer of the whole of the right of occupation over the whole of the land. So what we are saying is that we have right of occupancy over the land. Section 25 is saying that you cannot transfer, when you want to transfer, you must transfer the entire land. It must be the entire land that you are transferring. It does not allow you to fragment, and then begin to sell or to do it in pieces. Circumstances where you see people selling in pieces, they are doing that in violation of Section 25 of the Land Use Act, which says that as far as it's concerned, it deals with the transfer of land not subject to customary law, by providing that no deed or will shall operate to create any property interest over land except that of a plain transfer of the whole of the rights of occupation over the whole of the land. So you cannot break your right of occupancy into two. You cannot break the land into two. That's what Section 25 is saying. If the land is not affected by customary law, when you are transferring, it must be the entire right of occupancy and the entire over the entire land. So now the creation of successive ownership, by way of settlement contravenes the provision, but in no way interferes with the right to grant lease, sublease, and then mortgage title. So now what I'm trying to say in essence is that you could transfer the land, you could mortgage the land, you could transfer the land, you could mortgage the land, you could do this, you could do a stock list, but you cannot do settlement as far as Land Use Act is concerned. So now, hello, somebody's raising up his hand. Hello.
Yes, excuse me, sir. Can you hear me?
I can hear you.
Okay, thank you, sir. I just wanted to request that you please take that section 25
Okay, section 25 is saying that
again. I don't understand it, and so it's kind of like affecting my understanding of what you said afterwards.
Okay, now what I'm saying is that if you have a right of occupancy over a land, and that land is not affected by customary law. For example, you have a property that is not affected by customary law, anywhere it is situated. Now, what now happens is that you now want to transfer the land and the rights that you have over the land. What the law is saying is that you must transfer your entire right of occupancy and also your entire right of occupancy over the whole of the land. Are you together? Hello? Hello? Hello?
Yes, I'm listening, sir.
So that is
I'm listening, sir.
That's the purpose of Section 25. It says that when you transfer the land, then let's assume that you have a right of occupancy over the land, and you want to make a transfer of a land that is not affected by customary law, a land that is not affected by customary law. Your transfer of that land must be the entire right of occupancy that you have, or otherwise, you probably want to lease it. Otherwise, you probably want to sublet. Otherwise, you want to mortgage. Law will not stop you from doing a mortgage. Law will not stop you from doing a lease or a sublease of your right of occupancy. But if you are doing a transfer, if you are doing an assignment of that right of occupancy, it must be the entire right of occupancy over the whole of the land covered by that right of occupancy. Did I make myself clear?
Yes, sir.
Okay, so
Yes,
we're
sir.
not
Thank
saying
you.
that, we're not saying that before we go to doctrine of settlement, we are saying that doctrine of settlement, we'll understand it, but in a way they contravene the provisions of Land Use Act stated in section 25. But we'll get there. So the summary of what I've said in this paragraph is that Land Use Act in section 25 deals with the transfer of land that is not subject to customary law by providing that no deed, whether you do it by deed or whether you do it by will, but you are transferring and you are transferring your right of occupancy. It says that such transfer shall operate to create, it says that no deed or will shall operate to create any property right over the land except that of a plain transfer of the whole of the rights of occupation over the whole of the land. The whole right of occupancy, the whole of the land, when you are talking about transfer that is in respect of a land not subject to customary law. So the effect of this is that we are not stopping you from doing a sublease or doing a lease or doing a mortgage over a land in respect of which you have a right of occupancy not covered by customary law, but you cannot transfer part of it and leave the rest, or transfer the right of occupancy in respect of part of the land, or transfer part of the right of occupancy in respect of part of the land. So it goes further to tell us that this provision does not say you cannot do mortgage, you cannot do sublease, but it is in a way that doctrine of settlement, that concept of settlement we are going to be learning here is more or less a contravention of the provisions of land use act, but we are still going to learn it before we finish this semester. Of course, it goes further to tell us that this provision of section 25 is not contravened where a joint tenancy is created, since the estate created is antithetic to any idea of fragmentation of land. Remember when we mentioned that if we do joint tenancy, it is unity of time, unity of purpose, unity of unity of time, unity of estate, unity of interest, and then so on and so forth, and unity of possession. Of course, totally, all of those features of joint tenancy does not in any way, contravene the provision of section 25 of the Land Use Act. But it goes further. A tenancy in common involves limitation of land to 2 or more persons with words of severance, showing that there's an intention that denotes, that donees shall take separate shares. Of course, insofar as the tenants have unity of cession, it also does not contravene the provision of section 25. So what I'm trying to say, we are trying to relate this to some of those things that we have done and some other things that we are still going to do. That's provision of section 25. Section 25 of the Land Use Act is saying that when your land is not affected by customary law, and then you have a right of occupancy over it, and then you want to do a transfer of that right of occupancy, you must do the transfer of the entire right of occupancy in respect of the whole land which is being affected by that right of occupancy. Anything short of that will be a contravention of section 25 of the Land Use Act, and it goes further to tell us that the ultimate effect of the doctrine of settlement is that it will, by one way or the other, be infringing on the provisions of the Land Use Act, and then to contravene it to some extent. We went further to say that it is possible for you to do a mortgage, to do a lease, to do a sublease in respect of that right of occupancy, but if you must transfer the right of occupancy, it must be total and it must be in respect of the whole land. And then we say that, of course, if you apply this to the doctrine of joint tenancy, you will find that it is not contravening it because there is unity of all of the title, possession, cession, time of whatever, of owning and rest of that. it now goes further to tell us that if we apply this provision of Section 25 to doctrine of to tenants in common, even though we know that it is limited to 2 or more persons, and that there's a word of severance showing that they'll be entitled to so and so. But the fact that there's unity, there's a unity of what you call cessation, there's unity of cessation, then it also will not contravene the provisions of land use act. Now we are coming to the doctrine of I'll give you an introduction on what we mean by the concept of settlement, and then we hope that by the okay, please do.
Yes, good afternoon. I'm sorry to interrupt.
No problem.
Okay, you mentioned that a person with a deemed grantee does not necessarily have to like obtain a certificate of occupancy, but is deemed to have it, right? And you've also my question is, in case where he chooses to transfer rights in, and you mentioned that like we can infer that doctrine of estates, like his origin of the land comes similar to that of what applies in England, relation to doctrine of estates, because he does not have a limitation of years.
Yes,
will this also apply after we also apply to a transferee if he transfers rights in the land to
absolutely
another person?
Yes.
In as much as the person does not obtain a certificate of occupancy.
Yes.
Okay. And
okay,
I think that answers my second question. Thank you, sir.
Okay, yes, it can continue to transfer like that. Let me shed more light on that for you. Assuming that before land use act came, you have your father has registered a deed of conveyance in his name or your name in respect of a land, or his name, because you would not have been giving birth to that in his name since that time, maybe in 1946, 1956, 1966, or 1976, in respect of a land at Ikoyi or Victoria Land.
So we can hear you again.
Oh, so sorry, please. So sorry. Hello?
Welcome back.
Hello, can you hear me?
We can hear you now, sir.
Okay, I'm trying to elucidate on that last point. What I was saying is that right of occupancy, land user says that your right is limited to statutory right of occupancy, thereby removing all opportunity or all rights to hold, unlimited right to hold interest in land. Now, section 5 and 6 says that I will expressly grant you right of occupancy. And in practical times, what they give to you is no more than 99 years. Section 34 and 36 that if you own that land before the advent of land use act, you'll be deemed to be the deemed grantee of right of occupancy in respect of that land. And because you are deemed grantee, your right will be said to be infinite, because no measure of time is given to you to hold the land. And what we are saying is that this does not contravene the right of the governor to own all the land in the state. If the theoretical ownership of land by the crown in England does not stop people from having freehold interest. So if we say that section 34 and 36 will amount to freehold interest, we are not in any way contravening the provision of the Land Use Act. And the reason why you're right is more or less infinite, because they did not give you any measure of time over which you are going to hold the land. And you are not under any compulsion to come forward, to come and surrender that right, to change it to certificate of occupancy. Coming back to the question that you have also asked, what that means is that I can transfer that same interest to another person, and so on like that, until eternity. Are we together? Because I have not had the certificate of occupancy that's limiting my right to enjoy the land, my right to enjoy, to have the cessation to a particular period of time. I'm not sure whether I'm making any point.
Yes,
Hello?
you are. Thank you very much, sir.
All right, thank you very much. So we want to come back. We want to start discussion of. We want to start discussion on. Hello.
Hello, sir. Can you hear me?
I can hear you. Can you hear me?
Yes, I can hear you, sir. I have a question, but it relates to the last class. Can I continue?
Yes, continue, please.
Okay. So my question is that so I've already created a scenario, so I'll be able to explain it. So let's assume Iya Ibeji in her will, she devised a land to Taiwo and Kehinde without any words of severance. So they are holding it as joint tenants. Then Taiwo goes ahead and he went and create mortgages.
No,
They say
if you don't tenant, no, don't forget about the ultimate application of Land Use Act to joint tenancy.
Okay.
Please don't forget.
Okay. So can I paint this narrative?
Hello?
Sir, can you hear me?
Yes.
Okay, so I wanted to ask that if Taiwo
Please
go
don't
and
forget, don't forget the ultimate application of the provisions of Land Use Act that I have taught you concerning joint tenancy and then tenancy in common. So because I don't want us to waste time on that again.
All right. Okay. Thank you.
Please don't forget those. Remember what I told you about the effect of Land Use Act on joint tenancy and tenancy in common. Did you still remember? Hello?
Yes,
Hello?
sir, I remember.
Okay, so please refer to it and then apply it to the scenario that we have on hand. Okay, now, are we together? Can you hear me? Can you people hear me?
Yes, sir, we can hear you.
Okay. Now we want to talk about the concept of settlement. Are we together?
Hello, sir.
We want to talk about concept of settlement.
Hello, sir.
Hello, I can hear you.
I'm
Hello?
sorry. I just have a quick question. A quick question, sir. Yeah, so my question is with respect to joint tenancy, or rather co-ownership. So I wanted to ask that if a father should, live in his will that, his property should be given to his children in equal parts. What does that mean? Does that refer to a joint tenancy or a tenancy in common?
No, if it says that it's that tenancy in common, because it has so given them, yes, it says that separate shares. It says give them in so and so. That's separate shares. That's
so equal parts means separate shares. Oh, okay,
yes, exactly.
Thank you, sir.
Yes.
So we have another class now.
Oh my goodness. Would you ever finish this course?
159.
Okay. The price you have to pay is that you have to. When is lecture going to stop?
2 p.m., sir.
No. I mean, as in the lecture time. When is it going to start?
Next week, sir.
Next week, sir.
Next week.
We have only next week, Abby.
Yes, sir.
Yes, sir.
Yes,
So we
sir.
have Tuesday and Thursday to finish.
Yes, sir.
So you have to bear with me. When I come to class, we have. They say, how do they put it in the word of the Muslim? They will say that you people have eaten your sari, so you are going to fast. So when I get to class, I'm going to be very fast than I have been going on.
All right, sir.
Okay, sir.
Oh goodness.